Hi, this is your friend, not your friend, no, I'm on your side, Dr. Cora Stack. And I've just authored a paper which is the result of a lot of work over a number of years and a lot of scholarship, a time where I engaged in deep scholarship, but I didn't actually write. I hadn't it figured out, or I hadn't enough to kind of feel that. But the title of this video is it's when courts stop checking power, how adversarial justice is failing democracy. Now, I've been looking at a lot of the recent cases that are coming out of the courts, particularly the high courts, and some other cases, and I've been trying to look at patterns between the different cases, and certainly there's a kind of a pattern emerging which is more like systemic than there's similarities which are more than just coincidental, shall I say, in the judgments. And it seems to me there's undue deference towards establishment situations, or perhaps the state. And the question is, why is this happening? How is it that lay litigants are getting so kind of annoyed with the judges? There's a reason for this, because they're not getting justice. And then the question is this the right system in the first place? I personally think it isn't. I think courts should be, certainly, their role is fundamental in our democracy, but I think we need to have a rethink about what justice is all about and how it should be administered and delivered. So this is where I'm coming from. And my papers on access to justice, which emerged and are getting a lot of attention worldwide, so this is not unique to Ireland. But I think what's interesting here is the fact that there's a number of high profile cases, and I've been looking at the judgments and the excellent legal commentary coming from the Burke campaign. They're very good at the legal. They're very good at the legal commentary is brilliant. But that has given me an opportunity to examine similarities and patterns across a number of different judgments, and it's strikingly similar. And the kind of thinking, the doctrine, the balance of power, and there's too many similarities for this to be, just unique. No. It's a structural problem, and now I've looked at it internationally, and it's really very much on the money in terms of what's happening internationally. So we have a convergence of these high-profile cases, and I've been charged a lot for my attendance. You'd imagine I'd be given, funds for my attendance here, given what I have discovered, and I'm trying to highlight how things can change for the better. So it's not about criticizing the judges or being a serial complainant or a whistleblower or anything like that. It's about looking for positive change. So and doing it in a way that doesn't label any particular judge in any way, or any counsel or anything like that. This is just symptomatic of the overall problem that we're going to talk about now. So when courts stop checking power, how adversarial justice is failing democracy. Now, that's not the title of my paper, but that's the title, of my video. Now, on the YouTube, they're now doing it. They're doing lovely pictures. You can see it in all the experts. But I'll show you just the pictures of how it should be in the court. Somebody said to me recently in a hotel, what a bag was I going to, a hotel when I was witnessing or observing a court case, which I was again interested in the reasoning, the judicial reasoning, and looking at the oral evidence and seeing how the oral evidence matched the judgment and the reasoning, and seeing was there reasoning behind the scenes, was there something else going on behind the scenes in certain cases and not in other cases, and how was this pattern so similar in so many other cases, and particularly yesterday in the case with Mr. Paul Daly and the people before profit. And I read that case and I said, that's the same. That's very similar. That has striking similarities to my own case. So it's not all about, lay litigants, although that's a huge issue that lay litigants feel very hard done by. It's not designed basically to suit lay litigants. I mean, there's no equality of arms, in my opinion, and this is a major issue. But there's two issues. There's the issue of the that the system is unfit for purpose for litigants in person, because the litigation is too expensive, and disputes have become extremely complex, emotionally charged, and the judges don't like emotion at all. They get very cross. Some judges are good at handling women and emotion. Other judges are they're not calm, and they get like this, and then they project their tension out on women, this sort of thing. And it's just a personality trait. They need to be handled in a particular way. But if you're not trained to handle these judges in a particular way, you're going to, they're going to trigger their defences. And some judges are not that defensive, other judges are very, very defensive. But like, it's trying to get around all this. And I don't think, tinkering with the system is going to produce the outcome. So this is my what I've thought about for many years, and there's a lot of areas gone into this. So it's a lot of thought and a lot of scholarship and a lot of deep thinking and reflection and observation, and being fairly hard done by in the courts as well, but that remains to be seen, allegedly. So when courts stop checking power, how adversarial justice is failing democracy. Now, this is not unique to Ireland, but I think what's interesting is that there's been a number of very high-profile cases, particularly the Burkes, but also Mr. Niall Byrne versus Antánis Stack versus Antánis et al. And I never thought I'd be, challenging Antánis et al. I never thought I'd be doing this. A judicial review, it was my first ever judicial review, and I did 80 edits, and then I was 80 edits I did, and then to be kind of torn to shreds by the judge. I was humiliated completely by the judiciary, but I felt that there was conflict of interest behind the scenes, allegedly. So I can't prove it, but I felt there was conflict of interest. But this is systemic. It's not even unique to Ireland. It's systemic. So what I think it's very interesting is that these high-profile cases taking up a lot of judicial time, and the judges are getting very cross with us, and they're annoyed and impatient. But together with these judges and ourselves, we have really highlighted a major issue with regard to access to justice in Ireland, which some of these judges have kind of, behind the scenes expressed, and some of them have expressed, maybe that there are issues with access to justice, but they can't change the system. So it's up to litigants to change the system. They probably would say it's up to the politicians, but if the politician won't do it, you go to the courts. And that's a process which you're entitled to do. But if the courts are always going to side with the establishment or the government, sure, you have no way of changing things. So, you can't say, go back to the politicians. And if the politicians are doing wrong things or whatever, or maybe sidestepping things or twisting things around or whatever, or not moving, then you go to the courts, like in Denmark recently. There was a major case about parental alienation, and it immediately forced the politicians to change their ways. So there are two routes to getting change. So the courts, are maybe not doing enough to help change, but they shouldn't be doing all the change either. But they have a rule, they have a role to demand change when it's necessary. So it's about the balance. So when courts stop checking power, how adversarial justice is failing. So most democratic constitutions promise this: the power will never go unchecked, that courts will protect rights, that justice will be accessible to all. Now, this is where I'm coming in. What is justice? But what happens when courts remain independent in theory, yet become unreachable in practice? I mean, that's my lived experience, that's my lived experience. In fairness, they let you out in the door, but they charge you. Yet become unreachable in practice across many Western democracies. This is what now I think is very interesting about the number of high-profile cases in Ireland, and I've kind of come in here, and I don't know why I'm here really, but I've been able to look at the patterns in a lot of the different judgments, and what I've seen is not unique to Ireland. It's structural, and it's to do with the design of the adversarial system, which has remained this way for years and years, and is resistant. Well, one says resistant to change, but there's nobody, running. There's too many people benefiting from it. But now the litigants are rising up, as we see recently, and I feel like there's a particular High Court judge with a lot of power was giving out about judges, litigants surrounding a judge, but what about all the injustice that's done to those litigants? I mean, I wouldn't recommend anybody, surrounding a judge. But if the judiciary are giving out judgments which are seen routinely to be unfair to lay litigants, the lay litigants will rise up. It's like the Easter Rising. And this is what they were doing, I think, here. So you have to rebalance and say, well, perhaps the lay litigants were saying, we've had enough of this injustice and we're not tolerating it anymore. And so change is required. So as another judge has said, the place to do your protesting is outside the courts. So that'd probably be a better way to avoid, you see. But you see, this is what happens. So, but I think it was a sign that things have to change. So rather than saying we need more Gardaí, no, we need a different system of justice. In which case, we would need much less Gardaí, allegedly. So across many Western democracies, a quiet shift is underway. Courts will still exist, procedures still operate, but meaningful accountability is slipping through the cracks. That's the rate when you see the cracks. That's why I have it Rhinestone Cowboy on the thing, the cracks. I see every crack in the dirty sidewalks of Broadway. Yeah, but you know what he has in the end, though? This video explains how adversarial justice is failing democratic accountability and why structural redesign, not minor reform, is now necessary. So the separation of powers. Oh, the beautiful pictures here in this. It's fabulous, but I can't. So the separation. I'm fascinated by this whole concept of the separation of powers. It's absolutely fascinating. We all go into court wanting this to help us. The separation of powers we really want, and then we find, oh no, not again. Or we lose yet again. But anyway, here's the payback. This paper. So the separation of powers is often taught as the diagram. There's a fantastic. There's a kind of this would be an illegal lecture. Legislative, executive, judicial. This is fantastic. This triangle. But constitution is not about structure. It's about function. And as Montesquieu famously argued, power must check power. I mean, we all heard that, in America, about unchecked power before the last presidential election there. But courts are not passive referees. They are meant to supervise executive authority and to protect rights and to provide real remedies, solutions. We use remedies is used regularly as a legal term for solutions when the state oversteps. Judicial independence is essential, but independence alone is not enough. If courts cannot be used, they cannot check power. So the next point here is the rise of procedural justice without substantive justice. Here is the problem we rarely name. Across democratic systems, justice has become increasingly proceduralized. For sure, everything has. In every workplace, people say we're overburdened with administration and procedures and rules. We can't do the job we're paid to do. Claims are filtered out through standing rules, admissibility thresholds, cost exposure, technical pleading standards. Most challenges to state power now fail before the merits are ever heard, because all of these things are, they're filters that are used to deny, the person go to the next stage. This isn't overt authoritarianism. It's something a little more subtle and perhaps more dangerous. This system remains lawful in form, but increasingly inaccessible in substance. And this is not unique to Ireland, but the convergence of cases that are currently annoying the judiciary, I suppose, and, bothering them, have really helped to highlight this problem, not just in Ireland, but globally. So they've really helped me in my research. They think they've charged me a lot of money, but the research isn't for me, it's for justice. So it's not about me. When justice becomes unaffordable, so like what the judiciary have done is really brilliant for me, but it's not helping me, it's helping reform justice. So we've all gone in there, and some of us we're all in different kinds of prisons, you could say. So I mean, I wouldn't, I'm for restorative justice anyway, so I'm not for punitive justice. So I'm against that kind of justice, but that's another video and another piece of research. I haven't. That's just when justice becomes unaffordable, accountability collapses. Now, this is a very important point. Legal representation has become prohibitively expensive in Ireland. It's the most expensive in Europe, allegedly. But civil legal aid has narrowed, complexity has increased, and as a result, I mean, you'll get from a lot of solicitors, the case is too complex, to take up too much time. And, if you're not a multi-billionaire, you're not going to get their help. And they're looking at their costs. They're not going to be able to get the money, and they'll have too much time. They might think you have a very good case, but they haven't the resources to help you when you can't put the money up front. So, it's a failed system in that regard. It can't. I mean, a system that only represents or only helps the multimillionaires or people on, the lower incomes, that's failing justice completely, because the squeeze middle then are, out of the majority of people then are ruled out of justice. So, and as a result, self-representation is no longer exceptional, it's structural. But sure, you can just go into the courts every day of the week and you see all these, and like they're doomed to fail, doomed to fail is the only word for it. But I had to use a famous phrase by a particular judge. But adversarial justice, but it's doomed to fail means that's premeditated. What would you call that? Justice, injustice, allegedly. Anyway, but adversarial justice assumes, this is why, adversarial justice assumes professional advocacy, legal fluency, and most importantly, equality of arms. That's assumed, even though when you go into a court and you see an army of solicitors and barristers literally on one side and one, you're thinking, there's no equality of arms here. This is a right under the Charter, or the EU Charter. It's a huge right, equality of arms. And sure, you can see, there's no arms there at all. And this is a legal army over here. And the judges, I mean, and you can see sometimes the judge taking sides with the army. And you're thinking, this is not justice. This is just, it's an example of injustice before you go in the door. Injustice written all over the case because of this inequality of arms. When these assumptions fail, neutrality does not produce fairness. It produces predictable exclusion. Yeah, you said this is bound to fail. Doomed to fail is a great word to describe what happens the vast majority of litigants in person. Courts often describe self-representations as difficult, emotional, poorly framed, or vexatious. These kind of words, which are sometimes true, but or they're not true in some cases, and they're true in other cases. But certainly, not all self-represented litigants are difficult, emotional, poorly framed. But the problem is not the litigant. It is a system designed for people who are no longer there. So let's look at the next point. Judicial deference is sometimes necessary. Now, people would say this is everywhere, that the only way you'll get promoted, and that famous case with that Chief Justice under, I've looked at it, I've examined that case. The editor, Geraldine Kennedy of the Irish Times, Bruce Arnold, took a case because O'Doherty, that minister, tapped their phones, and while the state, while the judge sided with them, he gave them pittance of a like he only gave them a tap. He only gave the government a tap, a tiny tap, and the money that they got wouldn't buy a car in this days. It was totally disproportionate to the offence. And if my phone is tapped, what should I get? Or my, what money should I be looking for? And how would I prove it? And who would check it out for me? With what funds? Judicial deference is sometimes necessary, but when it becomes routine, it becomes judicial abdication. Courts increasingly defer to executive on grounds of institutional competence, efficiency, democratic legitimacy. But when deference combines with high costs and self-representation, a dangerous accountability gap emerges. The state becomes a repeat, well-resourced player. Citizens become filtered out. Executive power expands, not because courts are attacked, but because they quietly withdraw. So this failure is not just legal. These are some interesting concepts that I'm examining now. It is epistemic and moral. Adversarial systems privilege technical legal speech, but many communicate harm through narrative, lived experience, context, when those forms of knowledge are discounted or minimized, that's kind of known as gaslighting, people are wronged as knowers. This is known as epistemic injustice. That's Fricker's concept here. And when institutions that promise fairness deliver predictable exclusion, people experience moral injury, a profound sense of betrayal by the justice system itself. This erodes trust, and democracies cannot survive without trust. Why self-government can't fix this? Judicial councils are meant to protect independence. Now, I've looked at judicial councils, around the world to see, what, how they perform, in terms of accountability, and there's again a striking similarity pattern emerges. So judicial councils are meant to protect independence, but when judges oversee their own institution, systemic problems are often individualized, minimized, or dismissed. Patterns of exclusion are reframed as misunderstanding, dissatisfaction, emotional reaction. This is not bad faith, it's an institutional blind spot. Self-governance cannot correct design failure. So where I'm coming from is, how are we going to fix this? How are we going to fix it? This problem. So what I'm suggesting is arbitration first justice, structural democratic repair. So this is where my work on I think is having a most profound influence, or it's hitting a nerve or with a huge amount of people around the world, because this seems to be resonating with a lot of people, this idea. And I'm giving credit to all of the people that are going to courts at the moment, because looking at and witnessing, how people are treated, and looking at dispute resolution, really not just in the court system, but everywhere else, where I have some experience of, it seems to me that our oversight systems, and I think they're failing justice precisely because of the same thing, because of the conflict of interest, which is very hard to take out of a systems, these kind of systems. So there's conflict of interest everywhere. It's not obvious, but it's there. And these kind of systems are failing, and they're costing millions, all these, investigations and tribunals and all of that. And they rarely, if ever, deliver justice, because conflict of interest is the huge part of it. And you're exceptionally lucky if you get one investigation that goes in your favour without a solicitor. So arbitration first justice, structural democratic repair. So let's just look at what's here in terms of the images, which I think is good. Now, it doesn't look like a court. So let's just look at it here. Arbitration versus mediation, the key difference. You see the difference here, and then you go over here and you look at, like does that look like a court? So, you know what I mean? They're all the litigants with all their troubles, and then here alternative dispute resolutions, ADR methods, here, and you have the various things there. So to the script. This is my script. So what is the alternative? Now, I have looked around everywhere and I can't see a better alternative than this. So I'm just saying this seems to be common sense, a common sense solution. Not abolishing courts, so we're not, but repositioning them. I mean, if you like, we're raising them up, not pushing them down. They might feel it's the other way around. No, we're not abolishing courts, we're repositioning them. An arbitration first justice system, and I'm saying it's trauma-informed arbitration system, it acknowledges the human dimension to conflict resolution. So when a woman goes into court and is very emotional, that's not, go out, get out here, get out, you're emotional, that's not allowed in the court. You're not allowed to be emotional in court. Sorry, if you feel that you've been hard done by and you're emotional, there should be some way of, accountability for that, or some way of dealing with it. And people there that understand that emotions are part of the human condition, and that people have different ways of, and the one that can cover up their emotions should not get the justice. In fact, maybe the one that shows them is the one that's the most injustice. So and that way it could have been, but I people say, oh, you can't do this in front of a judge, you can't do that. Well, obviously but expressing emotions isn't something bad. This is part of the human and people have different ways of expressing emotions, but it shouldn't be seen as bad to express emotions. So, inappropriate. But I suppose people's bubbles burst when they feel they're being systematically or routinely denied justice for years and years. So an arbitration first justice system. So this is my thinking now. This is what's resonating with people. So I think it has something in it. There's something really in this which is important, and I think we have to congratulate all the actors and the judges indeed for their for their patience in dealing with the likes of myself, perhaps the Burkes. They may feel they've been in the door of the courts more times than anybody else, and I'm going in there now, and they've charged me, and well, for the moment, temporary charges, and I hope now from this paper they'll realise that we've all. I think it's brilliant really that there's been all these high-profile cases, including Paul Daly there, and I looked at that judgment, and I've looked at several judgments. So when I'm going into the courts, I'm looking for the reasoning, looking at the judgments, looking at the oral evidence, looking at the pattern between the actual judgment and the oral evidence. And I mean, they really don't want to see me in there at all because I'm too good at examining patterns. But the benefit of all of this is now that we're getting this kind of a solution opportunity for Ireland, which could not just help Ireland and the problems with the lay litigants, as they're getting very frustrated laterally, because the system is designed not for lay litigants clearly, but also for the rest of the world. That we should be, maybe not just the judges in their wisdom have actually portrayed or have shown their cards in a way that perhaps wouldn't have been shown if we had the likes of the Burkes or myself or others like watching what they're doing. And, others than watching, but it's just disclosing, the lay litigants are disclosing the unfairness of the system. But also, not just that, we have recent litigants that are exposing, problems with conflicts of interest, allegedly, which are huge. We all have conflicts of interest, and, those of us who are allowed to speak freely now, are few and far between, that have free speech, are allowed to have free speech. We're few and far between. And, we can pay a huge price, but, the ones of us that can, tell the truth or speak our truth, we're blessed really in any system to be allowed to do that. And we have to credit to our, people that are, an arbitration first justice system resolves disputes earlier, reduces costs, prioritizes truth seeking over victory, and accommodates complexity and trauma. Now, I have in my career kind of gone from viewing myself as a lecturer up there speaking down to collaboration. So it took me a long time to figure out how to, every day you're trying to get you're trying to perform better than the previous day. Every lecture is a new challenge, every opportunity. But really, I've gone from there, and I made mistakes earlier where I thought unduly punitive on students. Not that I was always very easy on students, but I changed my ways and I became more collaborative. And I found that being collaborative with students in a way where you're the boss, but you're hearing their voices and you're listening to them. And then you find maybe they have ideas that are better than yours. You say, oh yeah, let me take that one. I'll go there. I'll explore it this way. And I'm not, and I feel it's working better for students. They enjoy being part of a collaborative approach to learning, whereas you're steering the ship, you're not controlling. So there's a difference steering the ship but not controlling the outcomes, and the students are more part of the learning process. And I feel the collaborative approach has served me very well, but I've had to learn that that's the negotiation, negotiating with students and collaborating and all that approach I had to learn over many years, and that has improved outcomes right across the board. And you don't have the disputes then that you may have had earlier. There was one or two things that I did now, and I look back on it. I didn't listen to what I was, I could have resolved the dispute better. Now, it wasn't anything personal, but looking back at it, I said, oh, no, that student did have maybe I could have resolved it better, but that was years and years ago. But, so it's dispute resolution. So I could have, resolved disputes earlier, or I could have handled it differently. Reduce costs, prioritise truth seeking over victory, and accommodates complexity and trauma. Courts remain safeguards of last resort, not default battlegrounds. This strengthens, not weakens. This is the point. It strengthens, not weakens, the separation of powers. Judicial independence is preserved. Judicial accountability is restored by design. Now, this is the key issue here. And again, you have the courts. The crisis facing justice today is not illegality. It is inaccessibility. A justice system that exists only on paper cannot constrain power in practice. Democratic legitimacy depends on whether justice is affordable, accessible, truthful, humane. Structural design is not radical. In my opinion, it's constitutionally necessary. If democracy matters, justice must work for those without power, me being one of them, not only for those who can afford it. So this video by myself, it's based on my paper From Judicial Deference to Democratic Repair, Why the Failure of Adversarial Justice Requires Structural Design. And I would expect a lot of it. This is going to be a major piece of work, because I think it hits a lot of issues with regard to access to justice worldwide, not just globally. So I have to say, we'll have to thank all the Irish judiciary and the Burkes and Mr. Niall Byrne, myself, and the various people that were involved in a case about the super junior ministers, and all of those people. We have converged really into me being able to highlight and look at all the patterns and produce this piece of work. And in fairness, the judiciary have been very patient with me, and they're probably very cross with me. But I think maybe if they read this paper, they'll clap themselves on the back for their patience and allowing us in the door anyway, even if we were doomed to failure. But maybe the doom to failure is a diagnostic. It's a diagnosis in itself. This system is doomed to failure without Dr. Cora M. Stack's resolution or solution, a possibility prospect of adversarial justice. And now this isn't uniquely my own idea. It was based on a conversation with another actor years ago. So I won't mention who this actor is, but again, I was charged hugely for that conversation. But if we can get this, but I've thought about the trauma-informed in that conversation. It certainly wasn't trauma-informed, and but certainly there was something in it that I carried from that conversation. So perhaps we'll have done the state, as the late Charlie Hoy said, some service by going in and demanding accountability and justice from the courts, and perhaps maybe this paper will help to is a remedy for our nuisance, for being a nuisance to the courts. But the convergence of all these cases, I think, and has allowed me to highlight where I think the failures are, and they're systemic, and they're not personal to Ireland or to the High Court or the Supreme Court, but they are very, it's a huge issue, and it's hitting a real nerve worldwide. So the analytics are saying it's my most. I'm looking at the Protective Disclosures Act, and I'm looking at a number of other things, but they're saying that really it's my access to justice papers that are the real novelty here, my real contribution. And I'm only new scholar to justice, but of course I've always been passionate about justice. So it's but interesting enough, I think where I've got my my kind of sense of. I had a brilliant professor of mathematics, and he was called Professor Sean Tobin, and I was with him for 4 or 5 hours, and he was brilliant on law. He was brilliant on everything. He's very good on law and politics and all that sort of thing, and brilliant on English. I mean, there's nothing. He had a brilliant mind, and music and everything. I mean, he was a pleasure to talk to him because he was a great reader, and books up to here, and mathematically brilliant and everything. I mean, he was brilliant mind. But I think one of the last things he said to me on my last visit to his house was, Cora, I think you should have done law. You should have started law. I said, because he encouraged me to do mathematics, and he was a brilliant, but it's very hard to get funding in poor mathematics. And I have been, banging down the door of the powers that be, saying we need a better mathematics curriculum for our second level students. We need a differentiated curriculum, and I've been not heard or listened to, and it's something I'm very passionate about, how important it is to train our students, those that want to the top level. level at legal search, and we shouldn't deny them access to, to challenging areas where they're. And look at me now; I'm able, as a mathematician, able to use my mathematical skills to analyze and design, failures or in design because of my mathematical training. So that's what's underestimated in mathematics, education. Where's the relevance? Well, here's the relevance. Here's the relevance. Here's the solution. This is the relevance. Now I've applied my mathematical training to examining justice systems and looking for solutions to help. And I think if we can find solutions in the justice system, this way, dispute resolution will become more based on arbitration in every area, rather than all this investigations. And I think it was the head of the HSE is making a point of all these prolonged disputes. Well, if we had more arbitration and more collaboration, and I'm looking also at collaboration in hierarchical systems, that if we can have more collaboration between the circles in hierarchical systems, perhaps there is a lot of that going on behind the scenes of the courts. What do you think? I think there is. So but they have to collaborate now with the legal litigants. That's where the collaboration has to be, and that will be in an arbitration first system. So collaboration is a win-win. And that's really what adversarial is about. And so it's a win-win, I think, between the Irish judiciary, the Burke